Title III of the Omnibus Crime Control and Safe Streets Act of 1968, also known as the Federal Wiretap Act, prohibits employers from listening to the private telephone conversations of their employees and/or from publicly disclosing the contents of these conversations. Employers who eavesdrop intentionally when employees are justified in expecting their conversations to be private are in violation of the Act. Employers may ban personal calls and then monitor conversations for violations, but they may not listen to the entire conversation for the purpose of discerning its content. Employment perspective. Sheena Whitmore placed a call to her physician concerning the results of a blood test she had taken to determine whether she had contracted a sexually transmitted disease. This call was intercepted by her employer, who then stayed on the line to hear the test results. Is this an invasion of privacy? Yes. The employer's actions are in violation of Title III of the Omnibus Crime Control and Safe Streets Act. Whitmore was expecting privacy. Her employer invaded that privacy by listening to her test results. Employee email. Case 4.3, 4.4. The Electronic Communications Privacy Act, ESPA of 1986, is an amendment to the
All right. We are not going to do a lot of talking tonight. Imagine that. What we are going to do is we are going to work on my schoolwork.
Employee phone conversation. Access to personnel records. Employee access to personnel files in the private sector is not guaranteed in most states. However, many employers, as a matter of company policy, do permit employees to review their personnel files. Employee phone conversations. Employers may record the telephone conversations of their employees. However, they may listen only to the contents of the business calls for quality control purposes. Employers may note the frequency and duration of personal use, but they may not listen to the conversation. In some states, such as California, both parties must be apprised by a recorded message or a series of beeps that the conversation is being recorded. Title III of the Omnibus Crime Control and Safe Streets Act of 1968, also known as the Federal Wiretap Act, prohibits employers from listening to the private telephone conversations of their employees and/or from publicly disclosing the contents of these conversations. Employers who eavesdrop intentionally when employees are justified in expecting their conversations to be private are in violation of the Act. Employers may ban personal calls and then monitor conversations for violations, but they may not listen to the entire conversation for the purpose of discerning its content. Employment perspective. Sheena Whitmore placed a call to her physician concerning the results of a blood test she had taken to determine whether she had contracted a sexually transmitted disease. This call was intercepted by her employer, who then stayed on the line to hear the test results. Is this an invasion of privacy? Yes. The employer's actions are in violation of Title III of the Omnibus Crime Control and Safe Streets Act. Whitmore was expecting privacy. Her employer invaded that privacy by listening to her test results. Employee email. Case 4.3.4.4. The Electronic Communications Privacy Act, ECPA of 1986, is an amendment to the Omnibus Crime Control and Safe Streets Act. It extended people's privacy protection to email. The focus of ECPA is on interceptions. Once the email is received and stored on a computer belonging to the employer may peruse it. Unauthorized interceptions are subject to stiff civil and criminal penalties. Federal law also prohibits tampering with email. However, 3 exceptions apply to employers who want to intercept employees' email. 1. Consent by the employee to monitoring, best obtained in writing. 2. Where the employer is the provider of the email. This may apply to internal emails. But if incoming email arrives through an outside provider such as AOL, this exception does not apply. And 3. For the ordinary course of business, this may apply only to business emails, not personal ones. Employers may monitor email for quality control and sexual, racial, and abusive language. Employers should not divulge the contents of email communications. Employees should be on guard when transmitting email because of the limited protection afforded to them. Employees should not transmit or receive personal information through the email of their employers. Employees should not save personal files on their employers' computers. Most large corporations monitor email and employee internet use. A significant number of employees spend an hour or more each day surfing the web and reading and writing emails that are not work-related. Employees may argue that this is just a substitute for time spent on the phone or at the water cooler. However, companies retort that the costs run into the millions for lost productivity. In addition, lawsuits may result from sexual, ethnic, and racial jokes as well as sexually explicit emails or computer printouts. In effect, companies may be negligent if they do not have a policy in place and fail to monitor. The prudent strategy for companies is to create a policy alerting employees that they may be monitored and telling them specifically what is not acceptable. Companies may install a filter to block certain websites because they're objectionable or time-consuming. Employees accessing certain sites, such as those involving games, may slow down the company's computer network. Employees must remember that they are not at home. The computer and phone are both the property of the employer. The use of personal cell phones will provide a safe haven from monitoring, but the employer may prohibit excessive use on company time. The Electronic Communications Privacy Act was amended in 1994 to include cell phone use. Although employees may have some expectation of privacy in the work environment, courts are willing to overcome this for the employer's legitimate business interests. In most cases, requiring an employee password for access to the computer protects the employee's privacy interests with regard to coworkers, but not the employer. Most employers understand that employees need to take.
Again, again, I literally just started. It's going okay. It's always interesting when I'm kind of like reading about some of the laws that we have because like my company, follows policies and laws and stuff, but it's interesting where it comes from and like what some of the caveats are. Weren't there three? Oh, three. This device is absolutely insane. So yeah, it's interesting. I thought that an employee has legal right to view their personnel file. They don't. There's no law that requires you to have access to your employee personnel file. Had no idea. So that was really interesting to just hear that show up. So now we're going through like emails and phone calls and stuff like that. So I figure what I'll do, because I have 3 chapters a week to do, I'll do 1 chapter per night. And that time, by the time Wednesday hits, I finish the chapter and I can do the weekly assignment. So we're just going to get back into it.
Take care of some personal needs during business hours, and that the internet, email, or phone can facilitate the employee's ability to do so. It is the abuse of privilege that most employers seek to guard against. The best method to resolve this is through employee dialogue to develop a policy that addresses the concerns of both parties. Credit checks. The Fair Credit Reporting Act, FRCA, of 1970 requires an employer to obtain permission before hiring a third party to conduct a background check of an applicant or an investigation in the workplace involving an employee. After the report is submitted, a copy must be given to the applicant or worker. Notice or permission is not required for investigations conducted by the employer. Background checks can be a consumer report or an investigative report. A consumer report analyzes an applicant's credit history. FRCA allows consumer reporting agencies to furnish credit reports for employment purposes. These reports contain basic information about the individual and his or her credit worthiness. If the employer wishes to have a more detailed background check done by the consumer reporting agency or private investigator with regard to interviews of the employee or of the applicant's friends, neighbors, and coworkers, then notice must be given to the individual. In all respects, the employer's reason for doing so must be job-related. If the report goes beyond what is considered to be a business necessity, an invasion of privacy suit may ensue. If the individual falls into a protected class, race, gender, religion, national origin, age, or disability, then grounds for a discrimination suit may exist. Defamation. Defamation is a false statement communicated to at least one other person, orally or in a permanent form such as a writing, that causes harm to a third person's reputation. Libel is written defamation. Slander is oral defamation. Libel is actionable without proof of special damages because a writing remains in existence and could be distributed widely. The requirement for libel is a false statement that is published and read by someone other than the one about whom it is written. Slander is usually temporary and limited to the range of a person's voice, except when the oral statement is recorded and continuously broadcast on television, radio, or soundtracks. Slander requires a defamatory statement that is heard by someone other than the person against whom it is directed. Defamation. A false statement communicated to at least one other person, orally or in a permanent form such as a writing, that causes harm to a third person's reputation. Libel. Written defamation. Slander. Oral defamation. Employment perspective. Mary Thompson, an employee of Creative Publishing, names Roger Burton, a supervisor, as a reference for a job that will be a major step for her. Thompson will be making more money and have a title superior to Roger's title. Out of jealousy, Burton falsely states in writing that Thompson has appropriated ideas of subordinates without their consent and pawned them off as her own. Thompson is not hired because of Burton's statement. Does Thompson have a case for libel against Burton and Creative Publishing? Yes. Creative is liable because its employee made a false statement within the scope of his employment that deprived Thompson from obtaining a job. Employment perspective. Peter J. Roberts is a local attorney who has a well-regarded real estate law practice. Matthew Brady was formerly employed by Roberts as a paralegal. Out of revenge, he tells several real estate brokers who refer clients to Peter J. Roberts that Roberts has cheated his clients in several real estate deals. Even though Brady's statements are false, Roberts' business suffers a severe decline as a result. Does Roberts have any recourse? Yes. Roberts may recover general damages for the harm suffered to his business reputation. Truth and malice. Truth is an absolute defense to defamation when the statement made is fully true. However, the truth must be proved. A special rule pertains to defamatory statements made by the media concerning public figures. Even if the statement cannot be proved to be true, the media will not be liable unless malicious intent can be substantiated. Malice is the making of a false statement with the intent to injure another. Truth. An absolute defense to defamation when the statement made is fully true. Malice. The making of a false statement with the intent to injure another. Employment perspective. In the previous situation, assume that Matthew Brady's allegations concerning Peter J. Roberts were the truest words ever spoken, but that Brady has no way of proving them to be true. What would be the result? The result would be the same. Roberts will recover general damages. Although truth is an absolute defense, if Roberts meets his initial burden of proof, the burden then shifts to the person who made the statement. Invasion of privacy. Case 4.5. Personal privacy is protected against invasions causing economic loss or mental suffering. There are 4 distinct invasions: intrusion on a person's physical solitude, publication of private matters violating ordinary decencies, putting a person in a false position in the public eye.
No, selfless, it doesn't. I have to be aware of this because this is what my class is, personal law and ethics. So it literally is just going on. This is the driest book I've ever heard, because it is literally straight definitions and law cases. Like, this is all displaced's world of engagement.
By connecting him or her with views he or she does not hold, and appropriating some element of a person's personality for commercial use, such as photographs. Employment perspective. Rob Peters is a pension benefits specialist for Americana Insurance Company. One of his assistants, Brad Matthews, informs Peters that he must leave work 2 hours early this Tuesday for medical reasons. Peters asks Matthews for specifics, citing company policy. Matthews
I have to be aware of it as an HR person.
Matthews admits that he has the HIV virus and is being tested for AIDS. After Matthews departs early on Tuesday, Jim Waters, a coworker, asks Peters why Matthews left early. Peters responds, "You wouldn't believe it, Jim." Waters retorts, "Try me." Peters blurts, "Brad's got AIDS." Waters responds in astonishment, "No." Then Waters sends an email message to the other coworkers. Matthews' AIDS test comes back negative. Who does Matthews have recourse against? Because it was company policy for the manager to inquire about the specific medical condition of the employee, Matthews may sue Americana for invasion of privacy. Because Peters made a false statement about Matthews having AIDS, Matthews may also sue Peters for slander. Matthews may sue Waters for invasion of privacy and libel because the false statement was in written form. Peters and Waters may have been motivated by curiosity and gossip, not intent to harm, but the damage to Matthews' reputation still occurred. Publication of private matters that are newsworthy is privileged as long as it does not violate ordinary decencies. A false report by the media of a matter of public interest is protected by the First Amendment right of free press in the absence of proof that it was published with malice. Interference with business relations. A person who intentionally interferes in a business relationship through the use of fraudulent inducement or other unethical means that result either in an unfavorable contract or in the loss or breach of a favorable contract is liable for damages. The victim must prove damages, such as the specific loss of a customer, except where the nature of the falsehood is likely to bring about a general decline in business. Employment perspective. Phil Murray owns a service station in Mobile, Alabama. The on-the-spot car service company approaches Murray about maintaining its 12-car fleet. This opportunity would greatly enhance Murray's business. While they are still negotiating, Michael Dean, a former employee who was fired for stealing from the owner, circulates a false rumor that Murray is incompetent and unreliable when it comes to servicing cars. As a result, Murray loses the contract with on-the-spot car service. Thereafter, he discovers that Dean originated the false rumor, so he sues him for damages. Will Murray be successful? Yes. Dean's intentional interference with the contractual negotiations between Murray and on-the-spot car service caused Murray to lose the contract. Murray is entitled to the profits that he lost because of Dean's interference. Americans have safeguarded their privacy rights since the inception of this nation. Today, privacy is a major concern in the workplace. Employees have argued that the Fourth Amendment prohibition against unreasonable searches and seizures should be extended to office searches, email monitoring, tape recording of telephone conversations, and drug testing. With the advent of suspicionless searches, employees seem to be slowly losing ground. At the same time, employers feel that employees' reasonable expectations of privacy should give way due to the increase in employee theft and drug use. Employee theft. Case 4.1, 4.6. Theft by employees accounts for billions of dollars in losses for businesses each year. Employee theft can be narrowly or broadly defined. The narrow definition is the appropriating of personal property belonging to the business for an employee's own personal use. This appropriation can be temporary, but most often it is permanent. Employee theft is so prevalent because employees have access and motivation. Motivation may be caused by an employee's belief that he or she is not paid well or is not treated fairly, or because he or she sees or surmises that others are stealing. Employment perspective. Harry Tubbs and Pete Jackson work as a team for moving on van lines. They often make long-distance moves. After being assigned a job, they often complete it in less time by working late hours. Then they use the company van for making short moves from which they derive a profit. Tubbs and Jackson believe that as long as they perform their assigned work within the allotted time, they are doing their job and the company should not be concerned. Are they guilty of employee theft? Yes. Their theft is temporary, but the consequences are still severe. A van's useful life and maintenance costs will directly correspond to its mileage. Tubbs and Jackson's ventures are lowering the van's useful life to the company and increasing its maintenance costs. There is no difference between doing this and keeping the equivalent amount of money from a customer's cash payment. Both acts are theft. In addition, if they are in an accident while performing their personal work, the accident could subject moving on to liability for damages and injuries. If Tubbs and Jackson are injured, most likely moving on will incur medical expenses and workers' compensation benefits will be paid out. Tubbs and Jackson are not entitled to any of this because this occurrence happened outside the scope of their employment, but moving on may have to pay for it if the theft is not known. Some companies will want their employees prosecuted, but most will not because of the bad publicity it would bring. Dismissal with or without restitution is the most likely consequence. Conversion. Conversion is the unlawful taking of personal property from the possession of another. It is the converting of another's property for one's own use. Conversion may be made by mistake, but if it is done intentionally, it amounts to criminal theft, which is categorized as larceny, embezzlement, or robbery. Larceny is the theft of property. Robbery is the theft of property with the use of a weapon or with force. Conversion. The unlawful taking of personal property from the possession of another. Larceny. Theft of property. Robbery. Theft of property with the use of a weapon or with force. Employment perspective. When Marge Adams resigned from Pentangle Publishing, everything in her office was intact. That evening, Phil Thomas took the computer, printer, lamp, office supplies, and fax machine from Adams's office home with him. Thomas believed his actions were justified because it was most likely that Adams was not going to be replaced. Is Thomas's reasoning sound? No. Thomas has stolen company property for his own personal aggrandizement. Employment perspective. Mary Rogers works as a cashier for Macy's. She takes a break one afternoon to go to the restroom. She mistakenly leaves her handbag at the register. When she returns, her handbag is there, but her wallet has been removed. The store detective apprehends Debbie Wilson, a stock clerk, with Rogers' wallet in her hand. Has Rogers any civil recourse for Wilson's theft? Yes. Rogers may sue Wilson in tort for conversion. Wilson may also be criminally prosecuted for the crime of larceny or theft. Employee theft also occurs when a worker, usually a cashier or someone in billing, charges a customer, who is generally a friend, less than the amount owed. Although the employee may not be benefiting directly, the employee is instrumental in making the theft happen. There would be no difference between the preceding example and that of an employee stealing the merchandise and giving it to a friend. Both acts are thefts. Employment perspective. Missy Atkins is a waitress at the Busybody Diner. Atkins, who is shy and unassuming, wants to become more popular with the crowd at school. Whenever the most popular kids come in for burgers, fries, and sundaes, Atkins charges them only for the sundaes. Atkins' popularity is increasing fast, but is she gaining it at Busybody's expense? Yes. Atkins is guilty of employee theft. Embezzlement. Embezzlement is the fraudulent taking of property during the course of employment. A padded payroll is one example of embezzlement whereby a dishonest employee adds to a payroll names that are unauthorized and frequently fictitious. Checks are issued to these fictitious payees and endorsed by the dishonest employee. The person or bank receiving the endorsed instrument is not liable if all actions were in good faith and exercised with ordinary care. Embezzlement. The fraudulent taking of property during the course of employment. Padded payroll. An example of embezzlement, whereby a dishonest employee adds to a payroll names that are unauthorized and frequently fictitious. Employment perspective. Jonathan Rhodes worked as the treasurer for the Whitney and Myers department store. The store had 92 employees. Rhodes issued 95 checks each week. The 3 additional checks were issued to Kelly, Paige, and Evan, fictitious employees of the department store who supposedly worked with mannequins. Rhodes endorsed the names of the payees and negotiated the checks at the Williamsburg Savings Bank in return for cash. When the department store discovered Rhodes' scheme, he had left for a permanent vacation in the Bahamas. Has the department store any recourse against the bank? No. The endorsement of Rhodes, the imposter, is effective against the company as long as the bank acted in good faith. Theft of time. The broad definition of employee theft also includes theft of time. This encompasses longer lunch breaks, arriving late, leaving early, conducting personal business on company time, and goofing off. The age-old expression "time is money" is true. An employee who commits theft of time is not giving the employer adequate work in return for the wage provided. The employee is wrongfully inflating his or her wage at the employer's expense, which is a form of theft. Theft of time will not result in prosecution, but may result in dismissal or demotion. Employment perspective. Pamela Hall is a research assistant at Bull and Bear Stock Brokerage. She often spends time in the firm's library researching information on companies that her father, an avid market player, is interested in for investing. Is this act employee theft? Yes. Hall is guilty of theft of time. What if Hall had no work assigned? Then she should ask her supervisor for an assignment or educate herself on some aspect of the company's business. Employment perspective. Justin Sheldon is a data entry clerk for Miracle Drug Pharmaceutical Company. Sheldon often spends an hour or 2 a day making personal calls and running errands. He then works overtime at time and a half to accomplish what he could not do during the 8-hour day. Obviously, Sheldon is not closely supervised. In any event, is he guilty of employee theft? Yes. Sheldon is not only stealing time, but also charging the company at the overtime rate for the time he spent on personal business. Surveillance. Many companies use timesheets and electronic surveillance. Timesheets require an employee to justify how his or her time is spent during the workday, but such documents can be doctored. However, supervisors should be able to distinguish fabrications by comparisons with other similarly engaged employees and from experience with the work habits of the employee in question. Electronic surveillance is often installed by retail companies under the guise of identifying shoplifters. But equally important to the company is the electronic supervision of the work habits of its employees and the recognition of those who steal. Tape-recorded conversations are often used in the securities industry to record conversations between broker and customer for the purpose of verification should a miscommunication occur. Tape-recorded conversations can also discourage an employee from receiving personal calls. The use of polygraphs, otherwise known as lie detector tests, is severely restricted to cases in which the employer has a reasonable suspicion that an employee has committed a theft. Security. The mere presence of security guards is a deterrent to many employees who would otherwise want to steal. Security guards, though, cannot be everywhere and see everything. They're also expensive when compared with other alternatives. An additional method would be the use of inventory control. This requires limiting access to inventory to certain employees and instituting accounting controls and physical checks for verification. Inconsistencies can be investigated, and thefts are more easily traceable. When companies are lax in determining the existence of theft, it encourages employees so inclined to steal because there is little chance of detection. When controls are instituted, employees are more wary. Office searches. Case 4.5. Desk and office searches are often used primarily to locate illegal drugs and related paraphernalia, but also to identify the conducting of work unrelated to the company by the employee while on the job. Many employees find this to be particularly intrusive and an invasion of privacy. Most courts come down on the side of the employer if it has a justifiable business reason. However, employees who have been with an employer for a lengthy period of time develop a reasonable expectation of privacy in at least their desk and file cabinets. Company policy. Establishing a policy against employee theft is an important consideration for a company. The policy should include a definition encompassing all the property that the company feels would constitute theft if taken or allowed to be taken. The policy should spell out what the consequences for thefts will be and whether the company intends to have the employee prosecuted. A statement should be included stipulating that the policy applies to all employees from executives and down through the ranks. The company must disseminate this policy to all its employees along with conspicuous posting. Finally, the company should follow through rigorously, identifying and then enforcing breaches of this policy in a consistent manner. Fourth Amendment. Employee theft is a very serious problem. It undermines business profitability and gives unethical employees an unfair advantage over their honest counterparts. Some solutions are closer supervision through timesheets, electronic surveillance, desk and office searches, security guards, and tape-recorded phone lines. Many employees feel that such steps are an invasion of privacy, but what degree of privacy should an employee have at the workplace? The Fourth Amendment to the U.S. Constitution guarantees the right of the people to be secure in their person, property, and effects from unreasonable searches and seizures. In the workplace, absent an overcoat or a briefcase, what personal effects or property belong to the employee? Aren't the office and the desk company property? That would seem to be the case. Whistleblowing. Case 4.7, 4.8, 4.9. Whistleblowing is the notification by an employee to management about a coworker's unlawful activities or to the appropriate federal and state agencies about the employer's illegal activities. Whistleblowing. The notification by an employee to management about a coworker's unlawful activities or to the appropriate federal and state agencies about the employer's illegal activities. Whistleblowing is a noble and ethical act that sometimes requires a courageous effort on the part of an employee. Whistleblowers may be heroes in the movies, but they're often labeled troublemakers and treated with disdain by management and coworkers for the disruption they cause. Although some authorities encourage whistleblowing, more could be done to protect people who do risk their jobs for the truth to be known. On the other hand, some workers whistleblow as an act of spite or revenge. They may fabricate the event or blow it out of proportion. These workers are not acting in an ethical manner. Whistleblower Protection Act. The Whistleblower Protection Act, WPA, of 1989 was enacted to safeguard workers who report major violations of the law from being discharged or otherwise retaliated against by their employers. To qualify for whistleblower protection, an employee must provide a written disclosure regarding a violation of state or federal law through 1. Mismanagement, 2. Abuse of authority, 3. Substantial waste of public funds, or 4. Danger to public health and or safety. In the news. Helen Gu whistleblew on Takeda Pharmaceuticals by linking one of its products, Actos, with heart failure. Gu accused Takeda of failing to report the consumer complaints of heart-related conditions to the U.S. Food and Drug Administration, FDA. The law requires such reports to be filed with the Adverse Event Reporting System of the FDA. Helen Gu was a medical reviewer for Takeda. Gu claimed that the success of Actos was based on the public's belief that it was safe and effective. By misleading the public, Takeda increased its profits. Gu alleged that Takeda advised the medical reviewers to change their negative viewpoints to positive comments concerning Actos. Takeda retorted that whenever it learns of adverse health effects concerning one of its products, it reports this information to the proper authorities. However, no reports were made by Takeda with regard to Actos. Heidi Turner, Actos lawsuit alleges side effects hidden, lawyersandsettlements.com, March 9, 2012. www.lawyersandsettlements.com/articles/actos/side-effects-25-17499.html. False Claims Act. Case 4.10. The False Claims Act of 1863, as revised in 1986, protects whistleblowers against retaliation and encourages whistleblowers by providing whistleblowers, with a percentage of the funds recovered from those who defrauded the federal or state government. Sarbanes-Oxley Act. In 2002, the Sarbanes-Oxley Act was enacted in response to the false accounting reports that enabled Enron and other corporations to perpetrate securities fraud. To ensure enforcement of this act, employees and other individuals are encouraged to disclose information about a company that they reasonably believe is in violation of the federal securities laws or U.S. Securities and Exchange Commission (SEC) rules and regulations. These whistleblowers are protected from retaliation by their employer. They're entitled to reinstatement, back pay, attorney's fees, and court costs. Some state statutes also provide punitive damages. United States of America versus Emmanuel Chakwoudi Ekweruk. 2010 U.S. App, Lexus 7169, 5th Circuit. Case 4.1. The issue is whether the summary testimony given by a government witness is sufficient to overthrow the conviction of an individual for employee theft. Garwood, Smith, and Clement, circuit judges.
Oh, cool. It actually
Per
takes away
curiam.
the sand.
Emmanuel Ekweruk challenges his sentence and conviction for separate counts of theft by a bank employee, theft of public money, and aggravated identity theft. We affirm Ekweruk's conviction as to counts 1 and 2. Because the government concedes that the aggravated identity theft conviction was improper, we vacate in part and remand for resentencing. Ekweruk worked at an Internal Revenue Service, Lockbox, which was located in a Bank of America facility in Richardson, Texas. Bank of America had contracted with the IRS to receive and process tax payments on behalf of the IRS at the facility. As a temporary contract employee in the facility's Exceptions Division, Ekweruk had access to taxpayer payment checks. After Ekweruk tried to deposit a crudely altered stolen check at the Mesquite, Texas branch of Compass Bank, bank employees notified the Mesquite Police Department. The check was machine printed and made out to the IRS. Ekweruk had altered the payee line by hand with a black marker. Officers arrested Ekweruk, and an inventory search of Ekweruk's car revealed more stolen checks and money orders. The officers also found various IRS forms, papers containing other people's social security numbers and names, as well as several photocopies of checks, on which Ekweruk appears to have practiced altering the name of the payee. The face value of the stolen checks found in Ekweruk's possession was approximately $485,000. Ekweruk was charged with 1 count of embezzling, abstracting, purloining, or misapplying $485,059.76 from Bank of America. In violation of 18 U.S.C. Section 656, Count I, 1 count of embezzling, stealing, purloining, or converting to his used taxpayer remittance checks in excess of $1,000. In violation of 18 U.S.C. Section 641, Count 2, and 1 count of aggravated identity theft. In violation of 18 U.S.C. Section 1028A, Count 3. The jury returned a verdict of guilty on all 3 counts.
Yeah, no
sentencing,
kidding.
The district court imposed a guideline sentence of 42 months as to counts 1 and 2, and a mandatory sentence of 24 months as to count 3. As required by statute, the district court judge imposed the 24-month sentence on count 3 to be served consecutively to the 42-month sentence on counts 1 and 2. This timely appeal followed. Ekweruk's first 2 arguments on appeal relate to his conviction on count 3 for aggravated identity theft, which the government agrees must be vacated. He also argues that the testimony of Special Agent Winters was impermissible summary testimony and that his 42-month sentence as to counts 1 and 2 is substantively unreasonable. Because we vacate Ekweruk's conviction and sentence on count 3 and remand for resentencing, we need only resolve the summary testimony issue here. Some of Winters' testimony recapitulated the testimony of others, as the government concedes. Winters testified about the number and dollar amounts of the checks found in Ekweruk's car, even though these undisputed facts were covered by previous government witnesses. Other testimony was impermissible for different reasons. Winters testified that certain non-testifying taxpayers mailed checks to the facility where Ekweruk worked. In addition to being hearsay, offering the non-testifying taxpayers' statements regarding where they mailed their checks was impermissible summary testimony because supporting evidence must be presented previously to the jury to be used properly. Winters was testifying from personal experience when he stated that it appeared that Ekweruk practiced altering checks on some documents found in Ekweruk's car. The documents were admitted into evidence and were before Winters as he testified. Ekweruk characterizes this testimony as spinning the statements of previous witness, but it is clear that Winters was simply giving his lay opinion about the documents in front of him. Ekwaruk does not contend that Winters' testimony impermissibly relied on specialized knowledge. In sum, it appears that Winters did offer some summary testimony, but Ekwaruk overstates the amount of the summary testimony and, ultimately, the effect of this testimony on his conviction. The government's case against Ekwaruk was essentially uncontradicted, and Winters did not unfairly characterize the testimony of those witnesses he did summarize. We have affirmed convictions, despite finding some impermissible summary testimony in similar circumstances. Because we conclude that there is no reasonable possibility that Winters' summary testimony contributed to Ekwaruk's conviction, we find no reversible error. For the reasons stated, we affirm Ekwaruk's conviction as to counts 1 and 2. We vacate his conviction as to count 3. Judgment for the U.S. Case commentary. The Fifth Circuit ruled that the summary testimony of one government witness was insufficient to overthrow the government's case against Ekwaruk, which was otherwise uncontradicted. Case questions. Do you agree with the court's decision? Was the sentence sufficient for the amount of money Ekwaruk was attempting to steal? Is there an ethical resolution to this case? Israel E.
Rojas Velázquez v. José Figueroa Sancha.
2012 U.S. App, Lexus 6395, First Circuit.
What was
Case
that?
4.2. The issue is whether the employee suffered adversity on the job due to his political affiliation. Celia, Circuit Judge. Plaintiff appellant Israel Rojas Velázquez, a commander in the Puerto Rico Police Department, the department, complains that the department and several of its high-ranking officials abridged his constitutional rights by stripping him of certain duties and perquisites on account of his good relations with members of an opposing political party and 2, denying him due process. The district court dismissed the complaint for failure to state a plausible claim. The appellant began working for the department in 1986. Over more than 2 decades, he made steady progress. Even though he was a card-carrying member of the New Progressive Party, NPP, one of Puerto Rico's 2 major political parties, he received promotions during times when the NPP's main rival, the Popular Democratic Party, PDP, dominated the executive branch of the Commonwealth's government. He appellant's career path became rocky when his own party, the NPP, won the 2008 general election and regained control of the government. At that point, some departmental hierarchs began openly questioning his fealty to the NPP in light of his promotion to commander during the previous PDP administration. In short order, the department's newly entrenched leadership eliminated many of his former duties, retrieved his official cell phone and departmental car, evicted him from his office, and reassigned him to the performance of mundane tasks that he viewed as beneath the dignity of his rank. The appellant interpreted these serial workplace changes as a response to his perceived ties to the PDP. Despite the changes, however, he was neither discharged nor stripped of his rank, and he does not allege that his compensation was diminished. On the heels of these developments, the appellant sued the department and several of its leaders in the federal district court. Invoking 42 U.S.C. Section 1983, he alleged that the defendants had violated his First and 14th Amendment rights by taking adverse employment actions against him based on political animus. The defendants moved to dismiss the complaint. The district court dismissed the Section 1983 claims on the ground that the appellant had failed to show that the alleged adverse employment actions were either reprisals for engaging in constitutionally protected activity or deprivations of due process. After the appellant moved unsuccessfully to alter or amend the judgment, he filed a notice of appeal. The appellant's flagship theory implicates the First Amendment. In this regard, he notes that the First Amendment protects non-policymaking public employees from suffering adverse employment consequences in retaliation for engaging in political activity. As a general matter, the appellant is correct that non-policy-making public employees are protected by the First Amendment against adverse employment actions taken in response to their political activities and affiliations. Without such protection, those employees might be chilled from engaging in core First Amendment activities, such as joining a political party or expressing their views on public issues. Or they may feel compelled to support policies and candidates that they find odious. In this context, something short of outright termination can comprise an adverse employment action. If a public employer imposes unreasonably inferior working conditions on a non-policymaking employee on account of the latter's engagement in constitutionally protected activity, that imposition can amount to an adverse employment action and, thus, support a claim of constitutional breach. But this is not to say that the First Amendment protects against any and all adverse employment actions. It follows that in order to make out a Section 1983 claim under a political discrimination theory, a public employee must show that his conduct was constitutionally protected and that this conduct was a substantial factor or a motivating factor with respect to the negative employment decision. Applying these tenets, we agree with the district court that the appellant has not alleged a plausible claim of political discrimination. The appellant alleges that the defendant's misperception of his political leanings played a decisive role in his plunge into obscurity. He explains that this misperception came about as a result of his professional advancement during PDP administrations. To be sure, political affiliation itself is a constitutionally protected activity. But the appellant has not alleged that he is being discriminated against because of either his party preference or any other affiliation of a political nature. He, like the defendants, is a member of the NPP, and he does not in any way suggest that his party membership is at the root of his troubles. Here, however, the appellant has not averred that the defendant's misperception regarding his political loyalty, or lack thereof, was based on his membership in the PDP, his support for PDP candidates, his advocacy of pro-PDP policies, or any other protected activity. Instead, he frankly admits that he is a member of the NPP and alleges in substance that he has been penalized for his successful professional relationships with members of prior PDP administrations. This may be an undeserved penalty, but discrimination based on non-political associations does not implicate the First Amendment. Because he has not plausibly alleged that the defendants deprived him of any federally assured right, his Section 1983 claims were correctly dismissed. Affirmed. Case commentary. The First Circuit ruled that the employee was unable to connect the adversity he suffered on the job to his membership or support of a political party. Case questions. Do you agree with the court's decision? Should protection for political discrimination be extended to circumstances such as the ones described in this case? What would be an ethical resolution to this case? Kevin Sporer v. UAL Corporation.
I would love to hang out with
USDIST
this place and talk about this.
76852, U.S. District Court, Northern District, California. The issue is whether an employee's transmission of a personal email through his employer's computer can be monitored. White, United States District Judge. In this action, plaintiff Kevin Sporer contends that UAL invaded his privacy by viewing a pornographic video attached to an email Sporer sent from his work account to his personal account, and that UAL wrongfully terminated his employment. Sporer began working for UAL as a mechanic in 1987. As a mechanic, plaintiff was a member of the International Association of Machinists Union, and his employment was governed by a collective bargaining agreement, CBA. In 1998, Sporer became a supervisory employee at UAL, and his employment was no longer governed by a CBA. All of UAL's supervisors are at-will employees. Sporer testified that as a supervisor his employment was no longer governed by a CBA. Sporer's employment application provided that if he were hired, his employment would be at will. UAL's email policy provides, in pertinent part, message content must always be professional. It is strictly prohibited to transmit or store any messages or data that compromises or embarrasses the company, contains explicit or implicit threats, obscene, derogatory, profane, or otherwise offensive language or graphics, defames, abuses, harasses, or violates the legal rights of others. Sporer admits to having received reminders about UAL's email policy. Under the heading Privacy and Monitoring, UAL's Electronic Communications Standards provides: the company reserves the right to monitor all email on the company email system. In other words, as an employee, you should assume no right of privacy when mail transmitted on the company system. In addition, any messages sent or received for business or personal reasons may be disclosed to law enforcement officials or third parties without your prior consent. Sporer used a work-issued computer to perform his work at UAL. As far back as at least January 2006, a warning notice appears on all UAL computers when they are turned on. The warning notice informs employees that the computer system is a private computer system and that it is protected and monitored by a security system. Employees must click OK on the screen to clear the warning notice and proceed with use of the computer. On August 10, 2007, Sporer received an email entitled Amazing Oral Talent on his work email account from his friend, Harry Clancy. Sporer sent this email from his work computer over UAL's server to his personal email account. The email contained a pornographic movie of a woman orally copulating a man in various acrobatic positions. A few minutes after transmitting the email to his personal email account, Sporer emailed Clancy, "Thank you for the spiritual lift. However, I need you to use my home email address." Apparently, United Airlines Incorporated has a strict computer security policy, and these babies will get me fired. During a routine audit, UAL's Information Security Department came across the pornographic email Sporer sent to his personal email account. The Information Security Department forwarded the email to the Manager of Labor and Employee Relations, Kelly Elaine. Ms. Elaine forwarded the email to Kathleen Tetrev. In October 2002, Information Security had caught Sporer sending another inappropriate email from his work account. The email, entitled Skeleton Fun, contained a video of skeleton cartoon figures engaging in sexual intercourse. Sporer was counseled that the email he sent his personal account from work was inappropriate. Sporer was told that UAL's security system had found this email and that the email was inappropriate. During UAL's investigation of Sporer's transmission of the email in August 2007, Sporer admitted that 1. This was his second violation of UAL's email policy. 2. He was aware of UAL's zero-tolerance policy. 3. He had signed UAL's computer security agreement. And 4. The title of the email, Amazing Oral Talent, was suggestive. Sporer also admitted that, based on the title of the email and who had sent it to him, that the email might not have been suitable for work. UAL terminated Sporer for transmitting this pornographic email. Sporer's transmission of this email violated UAL's zero-tolerance policy on harassment and discrimination. The presumption of at-will employment may be overcome by evidence of contrary intent. In the absence of an express contract provision, the following factors may be used to determine whether there is an implied contract that an employee may only be terminated for cause: the personnel policies or practices of the employer, the employee's longevity of service, actions or communications by the employer reflecting assurances of continued employment, and the practices of the industry in which the employee is engaged. Sporer concedes that he signed an employment agreement in 1987 that contains an at-will provision. Nevertheless, Sporer contends that several changes in his status with UAL redefined his employment relationship. Sporer developed an understanding that no one at UAL was terminated without good cause. Sporer also relies on unidentified UAL policy governing the process by which investigations and terminations occur, and that he worked for UAL over 20 years. As noted above, Sporer does not dispute that he signed an employment agreement with an at-will provision. The existence of a progressive discipline policy is insufficient to rebut the presumption of at-will employment. Working for an employer for many years is similarly insufficient to rebut the presumption. Moreover, Sporer has not submitted any evidence to support his subjective belief that he could only be terminated for cause. Therefore, the court finds that Sporer has not submitted sufficient evidence to establish any agreement not to terminate him without good cause. Accordingly, the court grants UAL's motion for summary judgment on Sporer's breach of contract claim. Sporer contends that his termination was wrongful because it was in violation of his right to privacy, which prohibits the interception and disclosure of wire, oral, or electronic communications. To establish an invasion of privacy under California law, a plaintiff must demonstrate 1. A legally protected privacy interest, 2. A reasonable expectation of privacy in the circumstances, and 3. Conduct by defendant.
But you have
constituting
no
a serious
reasonable
invasion of
privacy on
Here,
company
UAL had a
email.
policy of monitoring its employees' computer use.
No
Warned
kidding.
employees that they had no expectation of privacy on email transmitted on the company system, and provided its employees with a daily opportunity to consent to such monitoring. Sporer fails to submit any evidence to the contrary. In light of such circumstances, the court finds that Sporer had no reasonable expectation of privacy in the use of his work email. For the foregoing reasons, the court grants UAL's motion for summary judgment. Case commentary. The Northern District Court of California decided that Sporer had no expectation of privacy in the use of emails in the workplace. Case questions. Are you in agreement with the court's decision? What if an
Yes.
employee accessed a pornographic email on his personal email account through his workplace computer? What if
Still.
an employee was observed accessing a pornographic email on a smartphone at work? Albert J. Muick versus Glenair Electronics. 280F.3D 741, 7th Circle 2002. Case 4.4. The issue is whether an employee has a right to privacy with the computer files in his office computer.
Oh shit, that one's
Posner,
close.
Judge.
Bye.
Muick, at the time an employee of Glenair Electronics, was arrested on charges of receiving and possessing child pornography in violation of federal law. At the request of federal law enforcement authorities, Glenair seized from Muick's work area the laptop computer that it had furnished him for use at work and held it until a warrant to search it could be obtained. He was later convicted and imprisoned. He has now sued his former employer, claiming that Glenair, acting under color of federal law, seized proprietary and privileged personal financial and contact data contained in files in the computer in violation of the Fourth and Fifth Amendments. The district judge rightly granted summary judgment to Glenair on Muick's federal claims. Muick had no right of privacy in the computer that Glenair had lent him for use in the workplace. Not that there can't be a right of privacy, enforceable under the Fourth Amendment if the employer is a public entity, which Glenair we have just held was not, in employer-owned equipment furnished to an employee for use in his place of employment. If the employer equips the employee's office with a safe or file cabinet or other receptacle in which to keep his private papers, he can assume that the contents of the safe are private. But Glenair had announced that it could inspect the laptops that it furnished for the use of its employees, and this destroyed any reasonable expectation of privacy that Muick might have had, and so scotches his claim. The laptops were Glenair's property, and it could attach whatever conditions to their use it wanted to. They didn't have to be reasonable conditions, but the abuse of access to workplace computers is so common, workers being prone to use them as media of gossip, titillation, and other entertainment and distraction, that reserving a right of inspection is so far from being unreasonable that the failure to do so might well be thought irresponsible. Judgment for Glenair Electronics. Case commentary. The Seventh Circuit Court ruled that an employer has the right to inspect an office computer or laptop being used by an employee. Case questions. Do you find the court's reasoning acceptable? Is there any situation in which an employee can have a privacy interest? Should guidelines be placed on what an employer may look for when inspecting computer files? O'Connor v. Ortega. For 80 U.S. 709, 1986. Case 4.5. The issue is whether the contents of a physician's office can be searched by the hospital that employs him. The resolution revolves around the issue of whether the Fourth Amendment protects the physician's privacy. O'Connor, Justice.
No.
This suit under 42 U.S.C. 1983 presents two issues concerning the Fourth Amendment rights of public employees. First, we must determine whether the respondent, a public employee, had a reasonable expectation of privacy in his office, desk, and file cabinets at his place of work. Second, we must address the appropriate Fourth Amendment standard for a search conducted by a public employer in areas in which a public employee is found to have a reasonable expectation of privacy. Dr. Magno Ortega, a physician and psychiatrist, held the position of Chief of Professional Education at Napa State Hospital for 17 years, until his dismissal from that position in 1981. As Chief of Professional Education, Dr. Ortega had primary responsibility for training young physicians in psychiatric residency programs. In July 1981, hospital officials, including Dr. Dennis O'Connor, the executive director of the hospital, became concerned about possible improprieties in Dr. Ortega's management of the residency program. In particular, the hospital officials were concerned with Dr. Ortega's acquisition of an Apple II computer for use in the residency program. The officials thought that Dr. Ortega may have misled Dr. O'Connor into believing that the computer had been donated, when in fact the computer had been financed by the possibly coerced contributions of residents. Additionally, the hospital officials were concerned with charges that Dr. Ortega had sexually harassed 2 female hospital employees and had taken inappropriate disciplinary action against the resident.
This case
Dr.
is just
O'Connor
all
selected
over the
several
place.
hospital personnel to conduct the investigation, including an accountant, a physician, and a hospital security officer. Richard Friday, the hospital administrator, led this investigative team. At some point during the investigation, Mr. Friday made the decision to enter Dr. Ortega's office. The petitioners claim that the search was conducted to secure state property. The resulting search of Dr. Ortega's office was quite thorough. The investigators entered the office a number of times and seized several items from Dr. Ortega's desk and file cabinets, including a Valentine's Day card, a photograph, and a book of poetry, all sent to Dr. Ortega by a former resident physician. These items were later used in a proceeding before a hearing officer of the California State Personnel Board to impeach the credibility of the former resident, who testified on Dr. Ortega's behalf.
I have no idea what I'm doing up here, by the way.
Documentation of one of Dr. Ortega's private patients under the California Medicaid program.
Like this, I'm happy with.
Did not otherwise separate Dr. Ortega's
but I don't know what I'm
property
doing
from
with
state
any of
property
that.
because, as one investigator testified, trying to sort state from non-state, it was too much to do, so I gave it up and boxed it up. Thus, no formal inventory of the property in the office was ever made. Instead, all the papers in Dr. Ortega's office were merely placed in boxes and put in storage for Dr. Ortega to retrieve. Dr. Ortega commenced this action against petitioners in federal district court under 42 U.S.C. 1983, alleging that the search of his office violated the Fourth Amendment. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Because the reasonableness of an expectation of privacy, as well as the appropriate standard for a search, is understood to differ according to context, it is essential first to delineate the boundaries of the workplace context. The workplace includes those areas and items that are related to work and are generally within the employer's control. At a hospital, for example, the hallways, cafeteria, offices, desks, and file cabinets, among other areas, are all part of the workplace. These areas remain part of the workplace context even if the employee has placed personal items in them, such as a photograph placed on a desk or a letter posted on an employee bulletin board. Not everything that passes through the confines of the business address can be considered part of the workplace context, however. An employee may bring closed luggage to the office prior to leaving on a trip, or a handbag or briefcase each workday. While whatever expectation of privacy the employee has in the existence and the outward appearance of the luggage is affected by its presence in the workplace, the employee's expectation of privacy and the contents of the luggage is not affected in the same way. The appropriate standard for a workplace search does not necessarily apply to a piece of closed personal luggage, a handbag, or a briefcase that happens to be within the employer's business address. Within the workplace context, this court has recognized that employees may have a reasonable expectation of privacy against intrusions by police. As with the expectation of privacy in one's home, such expectations have deep roots in the history of the amendment. Given the societal expectations of privacy in one's place of work, we reject the contention made by the Solicitor General and petitioners that public employees can never have a reasonable expectation of privacy in their place of work. Individuals do not lose Fourth Amendment rights merely because they work for the government instead of a private employer. The operational realities of the workplace, however, may make some employees' expectations of privacy unreasonable when an intrusion is by a supervisor rather than a law enforcement official. Public employees' expectations of privacy in their offices, desks, and file cabinets, like similar expectations of employees in the private sector, may be reduced by virtue of actual office practices and procedures, or by legitimate regulation. The Court of Appeals concluded that Dr. Ortega had a reasonable expectation of privacy in his office, and 5 members of this court agree with that determination. Because the record does not reveal the extent to which hospital officials may have had work-related reasons to enter Dr. Ortega's office, we think the Court of Appeals should have remanded the matter to the district court for its further determination. But regardless of any legitimate right of access the hospital staff may have had to the office as such, we recognize that the undisputed evidence suggests that Dr. Ortega had a reasonable expectation of privacy in his desk and file cabinets. The
No.
undisputed evidence discloses that Dr.
Completely
Ortega
disagree with
did
all
not
of that.
share his desk or file cabinets with any other employees. Dr. Ortega had occupied the office for 17 years, and he kept materials in his office, which included personal correspondence, medical files, correspondence from private patients unconnected to the hospital, personal financial records, teaching aids and notes, and personal gifts and mementos. On the basis of this undisputed evidence, we accept the conclusion of the Court of Appeals that Dr. Ortega had a reasonable expectation of privacy at least in his desk and file cabinets. Judgment for Ortega. Case commentary.
Nope.
The U.S. Supreme Court decided that after occupying the same office for 17 years, the employee is entitled to a reasonable expectation of privacy in his desk and file cabinets. Because their decision is specific to this employee, it does not provide guidance for employees who occupy an office for a much shorter period of time, or an employee who works in a cubicle or at a desk in an open floor plan with many others. Case questions. Do you agree with the court's decision?
No.
Why did the court bother to hear this case if it was
Not at
going to make a
all.
decision that would
And I'll
provide
tell you
guidance
why.
for
I'll tell you
employers
why
who
I
want to
completely
conduct
disagree
office
with
searches
this.
and for employees who want to know the extent of their privacy? Does the fact that the
I 100% disagree with that because you are on work property, work facility, work fucking filing cabinets, work everything belongs to work. So if you put your stuff inside of work property, they have the ability to search that shit. Like we have lockers at work. Anything that employees put in there, we can search. Man, I 100% disagree with that. Don't want to give work access to your stuff? Don't store it at work. The end. I have nothing personal on my work equipment at all. Nothing at work. The only thing that I have at work that would be considered personal is the fact that that's gonna fall apart anyways. Is like my web browser is part of like it's logged into my YouTube, right? And that's because that's where I play music. Actually, I would need to turn this blue. Yeah, I gotta turn this one blue too. Demolish. Yeah. Because it's all work equipment. Everything that is part of work equipment, yeah, they can have access to. No, that's a stupid judgment. That is insane that was the judgment that was given on that.
desk, file cabinets, computer, and office belong to employers give them the right to search their contents? Must notice be given to employees if an employer wants to conduct a search? Anthony Heinig and Jennifer Heinig v. Walmart Stores Incorporated. 2009 U.S. DIST Lexus 96644, U.S. District Court, Colorado. The issue is whether Walmart initiated a police complaint that led to the arrest of its employee, Heinig. Watanabe, United States Magistrate Judge. Anthony Heinig alleges malicious prosecution, and both plaintiffs allege negligence and outrageous conduct by Walmart, arising from Anthony Heinig's arrest and prosecution on theft charges, which were dismissed. To make out a viable claim for malicious prosecution under Colorado state law, plaintiff must prove that 1. The defendant contributed to bringing a prior action against the plaintiff. 2. The prior action ended in favor of the plaintiff. 3. No probable cause. 4. Malice. And 5. Damages. This court, however, does not need to go further than element 1 because this court finds that there are no genuine issues of material fact with respect to whether defendant Walmart contributed to bringing the criminal charges against Anthony Heinig. Defendant has shown with uncontroverted evidence that its internal investigation of suspected fraudulent returns led them not to Anthony Heinig, but to Mary Harris Rodriguez, a Walmart customer service manager. After interviewing Ms. Harris, defendant's district asset protection manager, Jared Manning, contacted the Broomfield Police for assistance in the investigation. Police officers then questioned Ms. Harris and reviewed videotaped footage and receipts. The police report shows that Ms. Harris, not Walmart, was the complaining witness against Anthony Heinig. There is no evidence that Walmart actively instigated or encouraged the prosecution of Anthony Heinig. Instead, Ms. Harris, not Walmart, told the police that Tony, whom she described as a former manager of the Wheat Ridge Walmart, was one of the men in the videos. The report states in pertinent part, on Wednesday, 080305, I responded to Walmart in reference to an employee theft. I arrived on scene and contacted the loss prevention district manager, Jared Manning, who told me the following. Jared was advised of several suspicious returns that were completed by sales associate Mary Ramirez. Jared completed an investigation into Mary's activities while she worked the front customer service desk. Jared reviewed the sales receipts, electronic transaction journal, and video recordings from the customer service desk area.
I need to
The
get more
investigation
basalt.
revealed Mary took several high-dollar returns without receipts from 070205 until 072905. Mary would
Gengar, are
complete
you
the
there?
receiptless returns and issue a gift card for the return amount. The gift card was used within minutes of its issuance. Mary would then complete a cashback return for the purchase made with the gift card. The total loss was over $22,835.62 for the month of July. Mary completed 41 transactions without receipts or gift card purchase receipts. Mary refunded the money for these transactions to those who presented them. The total money refunded was $20,282.74. Of the 41 transactions Mary completed, she let the person making the return leave with the merchandise on 5 separate occasions. The total amount of the stolen merchandise was $2,552.88. The customer service desk is monitored by store CCTV. These transactions were recorded. I reviewed some of the videotape. In one of the videotapes, I was able to see the unknown associate involved select merchandise from the sales floor and proceed to the customer service desk.
Gengar, I need to pay you money to come help me redesign my base. Like, I don't know what I'm doing. Like, I have a basic, like, oh, I kind of like this layout, but I know it doesn't look anything Atreides, like, at all. And I don't know what I am doing. By the way, oh, we're at page 31 of 43. Let's go! We're almost done with all my schoolwork tonight. Come on, focus. Right here. Get this beautiful face. There it is.
Mary completes the return and issues a gift card to the mail.
Subscribing
The same mail gift card
again?
for his return returns to Mary at the
Matt,
customer
why do you
service
guys
counter with
continue to
merchandise
subscribe to
he
this?
purchased with the gift card.
Is it because we're
Mary
here doing
completes the
legal
return
stuff?
of the items and gives the mail cash back. The mail left the customer
He
service
said
area.
ads.
Later
Hold on.
the
Yeah.
same day, the same mail completes another similar return with
Sorry,
Mary.
there's ads going
I told
on.
Mary
1
it was
second.
apparent she was not telling me the entire story. I asked Mary if she would tell me what happened. Mary told me the following. Mary stated she was aware that 5 people were
Ads are
making fraudulent
gross.
returns to her while she worked at the customer service desk. Mary described one white male named Tony as the male in the video. 2 other white males and 2 white females are involved. Mary knew Tony as the former assistant manager from the Wheat Ridge Walmart. Mary stated it was a big mistake to have made the returns. The police report further states that the reporting officer, not Walmart, presented the case for filing to the district attorney's office on August 9, 2005, and the district attorney accepted the charges against Mary Ramirez. The report then states a Walmart associate identified Tony, who was the former Wheat Ridge assistant manager implicated by Mary Harris, as Anthony Heinig, and the officer located a driver's license for Anthony Heinig. The officer then presented a photograph lineup to an assistant manager at Walmart, who positively identified Anthony in the photo array as being the male on the videotape identified as Tony by Mary Harris. Next, the officer reported that, and Tuesday, 090605, I filed this case with an affidavit for an arrest warrant with the district attorney's office. The warrant for Anthony Heinig was accepted and signed by the judge. The warrant for theft was entered into CCC with a statewide extradition. The bond amount was set at $5,000. Plaintiffs have not presented any evidence to controvert defendants showing that Walmart did not cause the institution of criminal proceedings against Anthony Heinig. The court thus need not address the additional elements of a malicious prosecution claim. Plaintiff's malicious prosecution claim fails as a matter of law. Case commentary. The U.S. District Court of Colorado decided that Walmart played no part in contacting the police, which led to the arrest of its employee, Heinig, for theft. Case questions. Are you in agreement with the court's decision? If Walmart did file the police complaint, would Heinig win the case? Did Walmart have the right to terminate Jennifer Heinig? David Healy v. The City of New York Department of Sanitation. 2008 U.S. App, Lexus 13734, U.S. Court of Appeals 2nd Circuit. Case 4.7. The issue is whether Healy's report of corruption is protected by the First Amendment. Summary order. Healy cannot establish a First Amendment violation because the reports of corruption, for which he alleges he was retaliated against, arose in the course of his official job duties.
All right, give me a second
Whether
because you're
public
talking
employee
shit.
speech
Hold on a
is
second.
protected-
Minus up, whoever did that is one you should pay, except for the gap above the pentashield. So, hold on a second. Like, let me get back on this. Like, we've been listening to a lot of stuff, so let's actually game here for a second. So this right here is 1000% Choma design. Like, this makes sense. Like, everything about this base makes sense, right? He's going up here, and it looks like he's exploring, building out into this area too, just building around. Like, is going to be more Atreides based, right? But all of this part of the base looks magnificent for Choma design. This is amazing. Mine looks like pure garbage fodder compared to that. Lady, I've been trying to keep your base powered. Yeah, but you need to go see Gengar's. Gengar's base is phenomenal. Gengar, your base is amazing. Like, your base looks so good. Oh, you think yours is hidden in the rocks? Wait until you see Gengar's base. It is. It is. Lady, I tried to keep your base as powered as possible. I turned off a bunch of stuff. You were sitting at like 400. I don't have the access to like do other stuff in your base, but I tried to do everything I could to keep your base shielded and powered on. Like a good neighbor, I try to keep it safe. Gengar, yours I couldn't check on originally. It was just like running out of power and I couldn't access anything. And I'm like, I'm just going to take stuff because I don't know what's going to happen to it. But this is also before they changed it where you couldn't bring in NPCs to do stuff. So we have 9 pages of court documents to get through. I'm not sure why. All I know, like, I could access your inventories, which I totally did. But the one thing that I couldn't do was quite literally, like, turn off equipment and other stuff. And I think it was because it was the early days of how they were doing toggling information. All right, we got 9 pages left. We're just going to burn through the rest of the court documents. We're beyond the definitions now, and now it's just to the applicable. So yeah, we're just going to burn through the rest of it.
From retaliation under the First Amendment entails 2 inquiries. 1, whether the employee spoke as a citizen on a matter of public concern, and, if so, 2, whether the relevant government entity had an adequate justification for treating the employee differently from any other member of the general public. Recognizing that government employers, like private employers, have heightened interests in controlling speech made by an employee in his or her professional capacity, the Supreme Court ruled that a public employee speaking in his official capacity is not speaking as a citizen for First Amendment purposes,
Yeah,
and employer
that's pretty
retaliation
standard.
for such speech does not justify the displacement of managerial discretion by judicial supervision. It is undisputed that Healy's inventory check was performed as part of his official duties. While performing this check, he uncovered what appeared to be evidence of corruption and reported these findings of corruption to his superior, Inspector McClernand. This report was therefore also made within the scope of Healy's duties, for it was based directly on the results of his inventory check. The fact that Healy made his report to the same superior who was responsible for directing his inventory check in the first place, rather than making an external communication, also supports the conclusion that there was no genuine issue as to the fact that this report was made in the course of Healy's official duties. Because Healy cannot establish that his First Amendment rights were violated by the defendant, his claim was properly dismissed. Case commentary. The Second Circuit ruled that Healy's speech was not protected because it occurred as part of his employment. Case questions. Do you agree with the court's assessment? How do you reconcile this case with the Fairley versus Andrews case that appears later in this chapter?
It's
Why are
very
employees who
weird to
whistleblow
hear
not
that
protected
name.
if they speak out? Roger Fairley and Richard Gakowski versus Dennis Andrews. 578F.3D 518, 2009 U.S. App, Lexus 18720, U.S. Court of Appeals 7th Circuit. Case 4.8. The issue is whether threats made by coworkers in retaliation for the guard's testimony are protected by the First Amendment. Easterbrook, Chief Judge. Roger Fairley and Richard Gakowski worked as guards at the Cook County Jail in Chicago. After their peers threatened to kill them, they quit and sued the other guards, complaint handlers, the sheriff, and the county. Guards at the jail regularly beat prisoners without justification. The harm plaintiffs complain of, however, is not the injuries suffered by prisoners, but how other guards reacted when plaintiffs opposed the maltreatment. For example, in April 2000, Gakowski objected when Fred Coffey struck inmate Brown. Gakowski followed up with an internal complaint. Coffey and other guards responded by taunting Gakowski, calling him a snitch who had no heart. For months later, a fight broke out in Special Incarceration Unit 2, which holds the jail's most dangerous inmates. After the prisoners had been subdued and shackled, guards Evan Fermaint, Noberto Bercajo, and Edward Byrne beat them. Fairley told them to stop. Byrne snapped, "They want to hurt my officers. K-I-L-M. They deserve to die." Byrne later told Gakowski, who had not seen the altercation, that he had twisted and jumped on an inmate's leg but couldn't get the bones to break. Byrne told Fairley not to file an incident report. Bercajo and Fermaint tagged Fairley inmate lover. Though the Department of Corrections general orders require guards to report any misconduct by their peers, plaintiffs say that this does not reflect reality. According to them, the jail's real rule is a ban on reporting misconduct, a code of silence. At the training academy, instructors told cadets to stick together and don't say any bad remarks about anybody. This attitude pervaded the jail. Tensions mounted when the inmates involved in the incident.
Man, there's a lot of legal issues in this one already.
They told other guards that, if subpoenaed, they would tell the truth about what they had seen and heard. Bercajo and Fermaint forcefully dry-humped plaintiffs by grabbing them from behind and simulating anal intercourse. Bercajo posted on the jail's bulletin boards pornographic cartoons featuring Gakowski. Supervisors repeatedly assigned plaintiffs to Special Incarceration Unit 2 without adequate supplies. Other guards refused to let them out to use the restroom. Byrne denied Fairley's request for paternity leave and refused to pay plaintiffs for overtime they had worked. The inmate lover and social worker flew freely.
There's
Gakowski
so many.
submitted an internal affairs complaint about the bullying in August 2002.
Oh my
Later that
God.
month, inmate Lipscomb attacked Fairley with a shank, cutting him on the wrist. Bercajo remarked, "You see that, Fairley? You F***K with people. That's how you get stabbed." Internal investigators dragged their heels. Ronald Prohaska told Gakowski, F. Fairley goes into court on this SI-2 case and tells the truth. He will F***K everyone involved. We always knew he was a weak link, and when a weak link can F***K everyone in the chain, then we have to bury the weak link. It's nothing personal. It's just business. Just like with your complaint trying to F***K fellow officers. Fearing further attacks, plaintiffs used all accrued leave time and then quit on February 4, 2003. Fairley had given his deposition a few weeks earlier. Gakowski was deposed in mid-February. Both testified at trial. The jury returned a defense verdict. They contend that defendants violated their speech rights by assaulting and threatening them for reporting abuse to jail supervisors and for their willingness to testify truthfully. They also contend some of the defendants violated their rights by preventing their complaints from moving up the chain of command. On to the merits. Fairley and Gakowski present two theories of recovery under the First Amendment. First, that defendants punished them for defying the code of silence by reporting fellow guards' misconduct. Second, that defendants bullied them to keep them from testifying. So here, plaintiffs reported what they deemed illegal conduct by coworkers, and that speech is not protected. The purported code of silence is a ban on filing complaints about guard-on-inmate violence. Such a policy might be foolish. It might expose the county to other lawsuits, but it does not offend the First Amendment, because what one guard says about another through the grievance system is part of the job, and the employer can discipline a guard for poor performance of work-related tasks. Bercajo, Fermaint, and the other guards are not plaintiff's employer, however. To recover under the First Amendment, a plaintiff must prove, among other things, both that his speech was protected and that the government's, more accurately, a given state actor's, justification for curtailing the speech was inadequate. Thus, it is conceivable that the court might hold the same speech, not protected vis-a-vis the employer, but protected vis-a-vis coworkers. If plaintiff's speech is categorically not protected, any state actor can punish plaintiffs in any way he wishes without incurring liability under the First Amendment. Why should the county's need for flexibility in running its jail insulate the actions of all state actors? If a code of silence is the rule, then the guards were merely enforcing the jail's policy. Although the guards' conduct might have been tortious or even criminal, witness tampering, plaintiffs do not want tort damages. They have framed their case in a way that can yield one of only two results. Either everyone is liable under the First Amendment or no one is liable. We merely reject the argument that prohibiting guards from complaining to supervisors violates the First Amendment. Plaintiff's second theory is that they were bullied and threatened in order to deter them from testifying. The jail likely requires guards to testify on its behalf and pays them for time at court. Testifying against the jail might not be part of the job, but that doesn't matter. Even if offering adverse testimony is a job duty, courts rather than employers are entitled to supervise the process. A government cannot tell its employees what to say in court, nor can it prevent them from testifying against it.
Man, he
Defendants'
needs a
only
water
contention is
station
that no
right
one
here.
retaliated against plaintiffs for testifying because the insults, assaults, and threats all preceded plaintiffs' depositions. This misapprehends the nature of plaintiffs' claim. But threats of penalties also are forbidden. That's why it can be misleading to speak of retaliation as the basis of a suit. The word implies that threats don't matter, and the district court here was misled. Threatening penalties for future speech goes by the name prior restraint, and a prior restraint is the quintessential First Amendment violation. The word retaliation has the potential, realized here, to divert attention from the rule that both threats designed to deter future speech and penalties for past
All right,
speech
we're gonna go look at Gengar's base
Retaliation
really
as
quick.
a legal theory comes from employment discrimination suits. The First Amendment protects speakers from threats of punishment that are designed to discourage future speech. Fairley and Gakowski can recover from any defendants who made such threats, though there are two additional requirements. One is proof of causation.
Here's
Plaintiffs must
Gengar's
show that their
base.
potential testimony, not their internal complaints, caused the assaults and threats.
Look
The
how
second requirement
amazing this
proof of
is.
damages. The largest item will
This
be lost income.
this
if
looks
plaintiffs
like
can
an
establish that the
Atreides
threats
house.
caused them to quit. Lesser threats, defamation,
This is
and battery,
gorgeous.
which are also can lead to damages if these are the sort of harms that would cause a
It's
reasonable
so
person to keep
amazing.
quiet. The judgment is affirmed to the extent that the district court dismissed plaintiff's code of silence claim. To the extent that it dismissed
Like this,
prior
like
restraint
that
claim,
looks so good,
the
dude.
judgment is reversed.
That
and the case
looks
is remanded
so
for further
good.
proceedings consistent
Yeah,
with
it's
this
sitting on your
opinion.
roof.
Case commentary. The Seventh Circuit ruled that plaintiffs may recover under the First Amendment upon proving that they were subjected to threats of punishment for their willingness to testify. Case questions. Do you agree with the court's decision? How do you reconcile this case with the Healy versus Department of Sanitation case in this chapter? Why
I
did the
don't-
First Amendment protect the guards from bullying threats by coworkers, but not for defying the code of silence by reporting fellow guards' misconduct? David F. Freeman versus Ace Telephone Association. 2006 U.S. App, Lexus 27052, 8th Circle. Case 4.9. The issue is whether the employee was fired in retaliation for his whistleblowing. Arnold, Circuit Judge. After Mr. Freeman was fired from his position as co-CEO of ACE, he sued his former employer for gender and marital status discrimination in violation of the Minnesota Human Rights Act, MHRA, as well as retaliatory discharge in violation of the Minnesota Whistleblower Statute. The district
Good
court
luck.
granted ACE's motion for
Good
summary
luck.
judgment on all claims. Mr. Freeman appealed from the grant of summary judgment only as to his whistleblower claim. Mr. Freeman claims that ACE fired him in retaliation for his report to its board of directors that the company's mileage reimbursement policy might result in violations of federal income tax laws. The company was reimbursing board members who carpooled to board meetings as if they had each driven separately, and it reported the payments as non-taxable reimbursements. Unless those board members who had not actually driven reported the payments as taxable income, they had violated federal tax laws. According to ACE, Mr. Freeman was fired because he had a sexual relationship with a female subordinate employee and lied about it. The board began investigating Mr. Freeman's relationship with the female employee in August 2003.
God,
At
it's
the
weird
end
when
of
they
that
say
month,
female
Mr. Freeman
employee.
submitted a letter to the board in which he admitted to having a friendly, not sexual, relationship with the employee and promised to sever that relationship. Based on some reason to believe that the relationship continued, however, the board began a formal investigation and informed Mr. Freeman of the investigation at its meeting on September 30th, 2003. Mr. Freeman first raised the mileage reimbursement issue with the board that same day. 2 weeks later, on October 14th, Mr. Freeman submitted a sworn statement to the board in which he admitted to having a sexual relationship with the employee and lying about it to the board. A week after that, the board decided to terminate Mr. Freeman and notified him of its decision shortly thereafter. The Minnesota whistleblower statute prohibits an employer from discriminating against an employee because the employee, in good faith, reported a violation or suspected violation of state or federal law to an employer, a governmental agency, or a law enforcement official. To establish a prima facie case of retaliation under the statute, Mr. Freeman had to show that he engaged in statutorily protected conduct, that he was subjected to an adverse employment action, and that a causal connection existed between the two. The timing of Mr. Freeman's dismissal is insufficient to establish a prima facie retaliation claim. As we have said, 2 weeks after Mr. Freeman made his report to the board about the mileage issue, he admitted, in a sworn statement, to having a sexual relationship with a female employee and continuing that relationship after he promised the board that he would end it. He also admitted, moreover, that he lied to the board president, his co-CEO, and the company's human resources director about the relationship, that he used a company credit card to buy Viagra to continue the sexual relationship, and that he purchased private cell phones for himself and the female employee so that they could communicate secretly. We believe that no reasonable person could conclude on this record that Mr. Freeman's report to the board about its mileage policy was causally related to the decision to fire him. Because we find that Mr. Freeman did not produce evidence of a causal connection between his report to the board and his termination, we have no occasion to address the question of whether he engaged in protected activity under the statute, or whether ACE's reasons for firing him were pretextual. For the reasons stated, we affirm the district court's order granting summary judgment. Case commentary. The Eighth Circuit decided that Freeman's alleged whistleblowing activity was unrelated to his dismissal. His misuse of corporate funds, his sexual relationship with a subordinate, and his lying were the determining factors. Case questions. Do you agree with the court's reasoning? Setting aside Freeman's misdeeds, would his alleged whistleblowing activity be covered under the statute? What would be an ethical resolution to this case? Lily R. Battle versus Board of Regents.
Man, I'm still tripping out over the fact
2006
dude
US
used the
Lexus
company card to get
26612,
Viagra.
11th Circuit. The issue is whether the False Claims Act protected a public employee from retaliation. Per curiam. Plaintiff worked in the Office of Financial Aid and Veterans Affairs, OFA, at Fort Valley State University, FVSU, between 1987 and 1998. In spring quarter 1995, while working as a work-study supervisor and Veterans Affairs counselor, plaintiff began to observe and document what she believed were fraudulent practices in the federal work-study program. Plaintiff took notes and made copies of suspicious documents, which she stored in a safe deposit box at home. In January 1996, the OFA was reorganized, and plaintiff's position changed to financial aid counselor. As part of plaintiff's employment duties, she was required to verify the completion and accuracy of student files as well as report any perceived fraudulent activity. Some student files previously handled by plaintiff's supervisor, OFA Director Jeanette Huff, were transferred to plaintiff. In examining these files, plaintiff discovered improprieties pointing to what she believed was Huff's fraudulent mishandling and mismanagement of federal financial aid funds. Plaintiff first confronted Huff about these improprieties in 1996, but Huff was dismissive and made no corrections. In late 1996, overwhelmed by the evidence of fraud, plaintiff met with FVSU President Oscar Prater, and told him that Huff was falsifying information, awarding financial aid to ineligible recipients, making excessive awards, and forging documents. Prater said nothing in response to plaintiff's accusations and took no remedial steps. Plaintiff confronted Huff on other occasions with folders plaintiff believed contained improprieties, but Huff made no corrections. In March 1998, plaintiff received a rating of exceeds expectations, the second highest available category, on her annual performance evaluation. The evaluation, however, also contained criticisms of plaintiff's performance. All of plaintiff's prior evaluations had rated her performance as exceeds requirements or outstanding. Despite the high score, plaintiff was not pleased with her 1998 evaluation. Plaintiff arranged a meeting with Huff's direct supervisor, FVSU Vice President of Student Affairs Cynthia Sellers, during which plaintiff complained that her performance review was unfairly low. Sellers advised plaintiff that, based on the score, plaintiff's evaluation was not bad and that she would likely receive a raise. During the same meeting, plaintiff told Sellers that Huff was doing stuff that was going to get our institution in trouble and awarding students aid for which they were ineligible. Plaintiff warned Sellers that she was going to tell unless changes were made. Sellers responded, "Do what you have to do." Plaintiff then scheduled a second meeting with President Prater to discuss her performance evaluation and to reiterate the improprieties, of which she had already informed him in prior years. During the meetings with Prater and Sellers, plaintiff did not identify specific student files that had been mishandled or provide documentary evidence, which plaintiff began collecting in 1995 to support her allegations of fraud. On May 25, 1998, plaintiff received a letter indicating the contract for her position as financial aid counselor would not be renewed effective June 30, 1998. Plaintiff appealed the non-renewal of her contract through FVSU and the Board of Regents of the University System of Georgia, alleging her contract was not renewed because of her attempts to expose Huff's fraud. A grievance committee investigated, conducted an evidentiary hearing, and upheld the decision not to renew. Plaintiff never spoke to anyone outside of FVSU about Huff's fraudulent activity until after she received notice that her contract would not be renewed. A month after receiving notice, plaintiff met with the Department of Education, DOE, and provided 61 pages of documents showing potential fraud and a 32-page analysis of student files. From June 1998 to February 1999, the Georgia Department of Audits conducted an independent annual audit of FVSU that revealed serious noncompliance with federal regulations and risk factors for fraud. The auditors formed no opinion on whether the noncompliance was intentional. Subsequent audits also revealed similar problems. Huff transferred out of the OFA in July 1999 and resigned in May 2000. In April 2002, FVSU reached a $2,167,941 settlement with the DOE to settle question costs identified by the state auditors in audits from 1997 to 2000 and in lieu of further file review. In June 2004, plaintiff filed suit in the district court, alleging 1. She was discharged in violation of the First Amendment for reporting her concerns about fraud, and 2. Huff, Sellers, and Prater knowingly submitted false or fraudulent claims to the United States in violation of the False Claims Act, FCA. The district court concluded that defendants were entitled to qualified immunity on plaintiff's First Amendment claim because the motivation for plaintiff's speech was unclear and pre-existing case law did not give defendants fair warning that plaintiff's speech must be treated as a matter of public concern under the circumstances. The district court also concluded that plaintiff's FCA claims were barred because they relied on publicly disclosed information for which plaintiff was not an original source. First Amendment retaliation claim. For a public employee to sustain a claim of retaliation for protected
Did you just
speech
crash
under
a
the First
computer?
Amendment, the employee must show by a preponderance of the evidence these things. 1. The employee's speech is on a matter of public concern. 2. The employee's First Amendment interest in engaging in the speech outweighs the employer's interest in prohibiting the speech to promote the efficiency of the public services it performs through its employees. And 3. The employee's speech played a substantial part in the employer's decision to demote or discharge the employee. Once the employee succeeds in showing the preceding factors, the burden then shifts to the employer to show, by a preponderance of the evidence, that it would have reached the same decision, even in the absence of the protected conduct. The first two elements are questions of law designed to determine whether the First Amendment protects the employee's speech. The third element and affirmative defense are questions of fact designed to determine whether the adverse employment action was in retaliation for the protected speech. In determining whether a public employee's speech is entitled to constitutional protection, we must first ask whether the employee spoke as a citizen on a matter of public concern. If the answer is no, the employee has no First Amendment cause of action based on his or her employer's reaction to the speech. W. Consider whether the speech at issue was made primarily in the employee's role as citizen or primarily in the role of employee. W. When public employees make statements pursuant to their official duties, the employees are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. Although the court acknowledged that exposing governmental inefficiency and misconduct is a matter of considerable significance, the court concluded the public interest was protected by other means, including a powerful network of legislative enactments, such as whistleblower protection laws and labor codes, not by permitting First Amendment retaliation claims based on expressions employees make pursuant to their professional duties. In this case, plaintiff admitted that she had a clear employment duty to ensure the accuracy and completeness of student files as well as to report any mismanagement or fraud she encountered in the student financial aid files. In addition, DOE guidelines require all financial aid workers to report suspected fraud. Plaintiff alleges her contract was not renewed because of her continuous efforts to expose the fraud within FVSU's financial aid department. These efforts consisted of attempts to disclose to both Prater and Sellers that her supervisor, Huff, was making improper financial aid awards and falsifying information in student files. By plaintiff's own admission and in the light of federal guidelines, plaintiff's speech to FVSU officials about inaccuracies and signs of fraud in student files was made pursuant to her official employment responsibilities. We conclude that because the First Amendment protects speech on matters of public concern made by a government employee speaking as a citizen, not as an employee fulfilling official responsibilities, plaintiff's retaliation claim must fail. Affirmed. Case commentary. The 11th Circuit held that Battle's disclosure of fraud by public employees was set forth in public documents accessible to everyone. Furthermore, Battle's allegations were made as a public employee, not as a citizen.
But there's
Case
usually
questions.
4 of them.
Do you agree with the court's decision? How could Battle have protected herself? Was the resolution ethical?
There it is.
Summary. Employers and workers have strong opinions on privacy, theft, and whistleblowing, and most often their interests are adverse. Absent litigation, these conflicts can only be resolved through a thorough understanding of the other party's concerns and the applicable laws governing privacy. Fostering communication is key here. Open or secret retaliation can result in a war zone where sides are drawn. This can only hurt the organization. Power struggles and authoritative behavior are ultimately no match for compromise and balance. Human resource advice. Consider the effect surveillance and security measures have on employee morale. Balance that against money lost through theft and slacking off. Refrain from listening to the contents of employees' personal telephone calls. Never utter statements about employees that are false or damaging to their reputation. Protect the privacy of employees by refusing to divulge confidential information. Refrain from reading the contents of personal letters or email directed to or sent by an employee. Investigate thoroughly and compile evidence before accusing an employee of theft. Never accuse an employee of committing any crime in front of others. If you are wrong, it's defamation. Share the problem that is forcing you to implement security measures with your employees. Encourage whistleblowers to come forward with information that, if not disclosed, would result in harm to the business.
Well, that's the end of my homework tonight. Impressive. So, a little context. It takes me roughly 15 minutes to copy the book into a Word document to be able to have Microsoft Word read it to me, because Microsoft Word has a very, I don't know how you'd say it, like natural speaking voice, natural sounding candor compared to the user reader. So that's why I have Microsoft Word up there, you know, reading the documentation. And that's also why I can't play any other game, because any other game takes way too much of my it takes too much attention for me to be able to focus. Like, I can't do a dungeon. I have to pay attention to patterns, what's going on, what other people, you know what I mean? Like, that's kind of why, like, Dune is like the perfect school game for me, because it is just straight, very simple. Oh, I want to build this, I want to do this, not much thinking. I don't think the light should be attached to that. That just seems really weird. Are we gonna do this walkway, this corner, or should we do this corner? I think we'll do this corner. Feels like it fits better. Demolish, demolish, demolish. Inclines. Stairs. Stairs. Whoa! Okay. Oh, because it doesn't instant build. That's why. That's why. That's why that doesn't build immediately. Okay, so build. Build. Demolish. Build. Okay, so now we have our stairway back. So now we're gonna build some walls. Is that the one that's... No, that's not the transparent one. So we're gonna demolish the wall. Demolish the wall. Build. Build. Okay. Oh, that actually does cover that quite nicely. Okay. God, it's nice to be able to see out these walls. Like, we couldn't see it with the last setup. Oh, we need, what is this? Interface, okay. I'm already out of plastone? Are you... Oh my god. Wait, am I mining it too quickly, or am I actually out of it and the system just an update? Yeah, I've got plenty. I've got plenty of stone. All right, there we go. All right, we are almost complete with our remodel here. Demolish, demolish, demolish. Oh, and demolish. Oh, wow, and demolish. I didn't realize it built all the way down here. So we'll need structural. Well, first things first, we'll need a floor. Structural. Come on, let go. There we go. There we go. Oh, this is gonna be... Oh, I have to move some things if I'm doing... Oh, no! I just realized I gotta take care of all my lights! Lame. Oh, it didn't build. Oh, wait, I gotta hold to build. Got it. I don't like... No, Dune is crashing. Everything is slowly getting back to the same page. No, I don't like that the lights get destroyed when you remove the ground beneath it. I don't think that should be the case in some instances. But I actually do need to get rid of my airship because we're remodeling this real quick. Which means I also need to move this bad boy. And then the lights will just be destroyed as we go across, which oddly enough is fine. All right, let's and the monkey flips the switch. kind of surprised I'm not getting any sun. Is it because I'm under my shield? God, having to replace this? Oh, that's gonna be a pain in the butt. It's still holding because it's attached. Okay. Okay, that's fine by me. So that's holding because of that. So I think for right now, we're going to do insufficient stability. I'll do that then. That's fine. The fact that the light is still there, just clinging, is very encouraging. The lights over here are very much destroyed. Well, now we're uncovered. Trust me, I don't want any of this. So drop, drop. I don't know why, but I do appreciate all the sand or worm activity right now. Definitely makes it feel a little bit more alive at the moment. So we're gonna do. I need a wall there. A railing there. Okay, so we have railings here. So how? I mean, I can just destroy that, and I can just destroy that. So this needs to be too high. I might just... have, like, solid Atreides wall. Right? Gengar, what do you think? Solid walls, or should I do window walls? Well, I mean, it's on the it's out here. Yeah, we'll do solid. I do need to see about where does this attach to then, right? Nowhere. So for this, like, I can't attach it to anything. So I think that has to be a normal wall. Like, I can't have a curved one for no reason like that. So that would be this one. What is it overlapping? I don't understand it. Is it too big? That's what she said. Is it too big? Is that why that's not snapping how I want it to? Let me destroy the lights here real quick. Hold on. Demolish, 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 demolish. We are learning so much about the game right now. So I can't snap onto these because of... I don't even know why. Okay, so I guess I can't connect it to, like, structures. But for the sake of argument... This is right on this one. But this is okay. Oh, absolutely not. This will not connect to that. Okay. Dude, these chomas need to shoot the real enemy. The Choma need to shoot down the Lance Rad. That's what they need to do. They need to stop bothering me. They need to stop shooting at all these other random ships, which, by the way, I don't know what they're supposed to even be doing. And they need to shoot down the Lancerad ships. 100%. I'm sorry, not Lancerad. Those guys. They need to shoot down the Sardaukar. That's what they need to be doing. They don't need to be bothering mom and pop me. They need to be shooting down the Sardaukar ships. You know, let the worms feed on those guys. It's because of fucking granite on me. Yeah, right? Like, no one cares about those assholes. Kill them. What? This is why I don't usually stream this game, because I'm just being nitpicky about stuff, you know? Gengar, you probably enjoy it because you're like, what the hell is this guy doing? Alright, as long as my ship is decay safe, I'm fine. Alright, so we got our walkway here. We've replaced most everything with our Atreides affiliate gear. Let's do a quick fly around real fast just to make sure we're happy with it. I mean, honestly, I feel like if I wanted to do full Atreides, I would literally just continue that wall straight down. And maybe turn these into the window walls. So I'm kind of thinking that's what I need to do, is I need to make it as opposed to this more open design. Shit, sorry. I would need to turn it more into like a fortress tower design. Like, I'm incredibly happy with this floor. I like this floor being just kind of open. But I think to go with the aesthetic of the house, I would have to have the open floor be up here more and have everything down here kind of be like essentially locked down. Because like the fortress design right there makes sense. That being round doesn't make sense because it's squared. So I might have to fix that. Why is that rounded anyways? Yeah, the only way that works is if... Wait a minute. Oh, I can't round this side because it goes into a security door. That's why. because the light's in the way. Yep. Yeah, I don't like the way that's just not lining up. So we're just gonna change that into a just a square, which would put that as a square. Demolish, demolish. Which would be walls. I don't have a double door because like this is my drive-through area. I intentionally wanted a drive-through ground floor here, which I mean notably we haven't done much with. I just destroyed the light that was right there, by the way. That's amazing. Yeah, we haven't done much with it, but that's the whole reason I've got two doors right here. Is because it's a drive-through door. I'm still ultimately trying to figure out like where I want to go with a lot of it, and how I want a lot of it to come across. I think I had a support beam right here. One of these, you know. Oh, I feel like I need to move this level up. Because I do have a very wide open second floor. But that means I need to figure out what I'm doing with this floor, which I have to redesign my power station. I have to redesign this area right here. I feel like I'm kind of getting it. Like I essentially need to turn those wall spikes into straight like walls all the way down for the Atreides Fortress design, because their design is very much a thing, you know? I feel like that's where this is ultimately going to be going. Which means I need to rotate. Actually, you know what? If I build walls right here, I don't even need supports. The walls are the supports. Come on, let go. Oh, yeah. That's what the Atreides house would look like. And then you'd put massive walls with the decals on the outside of it. This can ride straight into the ground. Those walls can go straight down. Hell, I think this one can too, right? No, I can redesign my walkway right there. But yeah, that's essentially what that is going to have to turn into, is just a huge fortress. And this whole lower section can be walled off, which will let me build out the ground a little bit more, because these are providing structural support for everything above it, which would make me use this. Yeah, I've got to move everything up into this level now. So I have to get it all off the second floor to have my crafting done essentially at this level here. Like, I'm getting the idea of it because I really do. I don't think I have a chome base near me. Because I do like the chome base of kind of having these open walkways. And I like having this exposed second and third floor. But I think I would need to expose it more up here and have the fortress more down here. So I have to move all my crafting to here, which would turn these two floors into workable floors. And there's a lot of overhead space because this is actually a gap and a half where everything down here is tight. My wind turbines are fine where they're at. I just have to redesign the ceiling section right there for it. But I'm starting to get it. And putting these as massive pillars like that just gives me that instant structure. Like, I can actually get rid of... Well, I mean, once they go all the way to the ground anyways. Because, like, they're providing the support as well now. Man, looking at it as a base is kind of, like, very different to wrap your head around. As a fortress, I should say, not as a base. Dude, I swear to Christ, if it's that rocket back up there. Hey, Astra. Yeah, I think it's time to move everything up to this level, just because I have a lot of open space now. Oh, that was loud. Thank you for subscribing. I appreciate that. Before I move all my storage containers, I kind of got to figure out the layout I want to do with this. Oh, wow, that hangs low. I gotta remember, though, I'm standing on... This isn't the half layer. This is the half layer above me. Like, this all here is the half layer. How are you doing this fine evening? There it is. That is the, how close is that? That's like 1,000. That's like 1,000 away from me right now, isn't it? Yeah, that's way out there. I mean, there it is. That's the start of the, which totally changes the layout of everything. It's crazy to think about. We started right here, you know? Like, this was the ground. This was everything. And then slowly... We've grown so much in this game. I'm glad you're having a good night. Happy, I hope you had a good Labor Day, Monday, whatever day it is for you. Somebody just ate a ship. It is Monday. Shit. Oh, you're on a private server. Okay, okay. I'm not that far in the game, honestly. I mean, what you see is where I'm at. I'm roughly at the I'm at the end of the aluminum era. Shit. Gengar, can you see what I'm going for? You see kind of the plan I've got at the moment? I'm busy. I'll check in a second. No. No rush at all. Figure out what's going on with this wall. How is this insufficient stability? You are the stability. You're the foundation. How far are you into the game, Astra? I feel like I should call this like my smuggler's entrance. Oh, it's blocked by the things. Okay. When does the new update come out, by the way? Tenth of September? Okay. What the heck is this? Holy crap. What are these? Oh, these are the big wingtip pieces. Okay, so these are mostly...
Sector weather alert. A large sandstorm is approaching.
Yeah, that's just what I need. Man, if only I could get this thing 2 pieces wide. That'd be really cool. Oh, there's a gap. I think there's always going to be a gap because of the way the stairs are here. Okay, okay, okay. Ooh. Oh, won't let me push through the sand, or I don't have another wall down there. All corners must be connected to a structure. That's so weird that the placement is blocked on those. I need to go get some water here soon. Oh, did that just break everything? It did. Wow, it's literally all because this rock right here is why I can do anything. So weird. Why does that line up perfectly, but this doesn't? Oh. That's why. That's what's giving me building authority. That's what's giving me building authority. I'm putting a wall right here. And that's why I can't go through it. What if I shoot higher? Is it the actual pieces here that are blocking it? Excuse me. It's the wall itself. That's really unfortunate. yeah, I forgot I built way out there. Or I gave myself permission to build way out there. Why won't you let me connect it? See, I gotta be real careful with messing with these walls down here. Because everything for crafting is right on this floor. All of my crafting stuff is right there. I'm debating if I want to keep the door here or just push it forward. Just bite the bullet. I think I'm just going to bite the bullet and do it. So demolish, demolish. Structural. Build. Build. Whoa. But I'm going to have to build bigger now. Because I got to start thinking about... well, I don't really think I'm gonna use a mineral. One of the big buggy things. Like, I got you guys for that crap. Plus, there's literally nothing here I would want to use on that level. Oh no, the buggy's cool. It serves no purpose for me. There's nothing here I would want to like use the buggy for. Like I'm in the far south. Like everything I want to mine is up here. I've got a buddy with a fort here. I've got another buddy with a fort here. Like I just jump in their equipment and start mining stuff. But there's nothing down here that I would mine. In just full disclosure. So yeah, having this here serves me no benefit. Nice. I just keep using my friend's crap. So that these don't let any light in. Got it. What about this? Honestly, since I've gotten my Thropter, I don't even touch any of my ground vehicles at all. So like the ground floor here really is kind of just for show. Like the last time I drove this, I literally drove it to move it. Yeah, I don't have enough of stuff to really do that with. The amount of casual that I am at this game is insane. I am running out of Palstone though, or Playstone. So we got to go do a basalt run here in just a little bit. All right. Before we do anything else down there, I need to, like, move essentially everything. Yeah, we have to move all of this up a floor. The blood I don't mind. The blood I don't mind just keeping back here, because above this is essentially just rock. There's nothing here. So the all the blood that we have, I feel like I'm just gonna leave like right here. But everything else will move up to this kind of area. Once I get the rest of these walls and stuff figured out. I think everything I have going into rock, I kind of have that 3. That design on. We're using that material. So we need to replace these 2 walls with this and that. There we go. That gives us a little more uniformity. God, those ships need to go away. What the hell am I trying to do here? I know what I'm trying to do, but like, what the hell am I trying to do? Because I'm getting into the half floors. That's what it is. This is the half floor area. Yeah. Okay. That's why. That's where my gap is. Okay. So we get rid of that, which will destroy all that. Fine. Build. Full wall. Which I don't think we can do because of this. Yep. There you go. Now it's built straight down. Well, the worm just ate something and or someone, so that's fun. All right, so it looks like our 200 meters. Holy cow, that's right next to us. So we've got a majority of our the foundational stuff done right now. Just need to figure out what I want the rest of this to look like. Oh, it's only 9:30. Feels like it's been going longer than this. How big is this? Oh, it's 3 wide. Okay, so it's 3 wide, and that's only a 2-banger door. Okay. I need to look at this from the outside. If only I had a flying ability. Oh, I do. Bless onward. Whoops. Alright, so this is fine. I got a wall off that. Got a little walkway over here. I think I'll put it right here. I got to get rid of these roof tiles and put like flat roof tiles. I don't know if I need this right here. If I need this type of support. Let's go remove my ship really quick before I absolutely set myself back. Okay, it's because this is here. Okay, so we have to ditch. This is the actual heights of stuff. Yep. Excuse me. And this is the part I don't understand. Like, why are there stability issues right now? So I think I need supports then. And this is the half floor issue. All right, so we should have no more stability issues now. So what I have to do is attach this to here somehow. Because they won't let you put a floor. Okay, I'm getting the idea. I'm seeing it come together. We're getting there. We're getting there. Yeah, the Chom had a nice incline piece. I just drank my entire suit's water. Ooh, almost ran off the cliff on that one. It's going. We are running into the issue of having a half floor again, but I'm getting creative about shit, what that looks like to get around. All right, so check it out. You'll appreciate this. So here is the floor, right? So we're gonna move everything up to this floor for crafting because there's more room and I can get rid of this. But because it's a half floor, like this all isn't attached to anything except for the plane that it's on. Because... Okay, wait, that's attached there. Why couldn't I build that? Wait a minute. Oh, I don't have a massive support beam going through it, do I? Why didn't it let me build that support beam then? Did I just do all that wrong? Break. And just like that, everything is working fine now. I was trying to attach it to the half plate right there. But I guess I don't really need to. Yeah, there it is. Insufficient stability. Oh, wait, which I think I can just fix with... How do I get that? Oh, I gotta delete this out. So we delete that. So how is it connecting around here? Oh, because the stability for this is built off the stability on that. Okay. That's why that's working. But it doesn't work over here because this is too far out? Yeah, see, the engine doesn't like it. Which is why I can't build anything here, and I can't cap anything off on this, because stability is not a real thing here. So even though... Yeah, see, I can't build a full floor, because the floor either exists there, which is on top of the support pillar. And if I build another support pillar, it's through the floor. See how that doesn't line up here because it's 1.5 floors up? I can already hear them. So what I did was I'm kind of playing around with arcing the wall up to here. Because I'm banking off of this. How did I do that a minute ago? I think I just bent it, right? Yeah. Something like this. because now the stability of this is built off the actual floor piece there. And put a couple of bracing joints on it. And then we can continue our roof. Oh, whoops, wrong way. Wrong way. Wrong way. All because I wanted to do something stupid. Is where this all came to be. I just don't get why I can't attach it to this, which is built on this. Maybe I need a simple support? Oh, I can't put this right here because the wall literally exists. That's why that doesn't line up. Alright, it looks like it's holding now because this piece exists. Nope. Oh, that's why it was holding. because of... Oh, okay. So that was existing because I put a brace right there? Oh. All right, so we go from here, we're up into this. I don't think I put this here. I think I need to brace it off of this little piece right here. So, we'll go here. Shit. Fun with geometry. So this is that attached to... Nothing. So all of the stability here is technically coming off of this one point here. So just to mirror it, so everything looks, you know, copacetic, we'll put that here, which will extend stability out to this region here. We can't cap it here because there's nothing for it to snap to. But we can, just for the sake of... Oh, there's a support pillar there. That's why. There. I need to go drop off these rocks.
Sector weather alert. A large sandstorm is approaching.
Oh, you know what? This should all be the standard tile. This shouldn't be the blue tile. This needs to be this tile. There we go. There we go. Now it's finishing up for the night. There we go. There, now it looks uniform across the board. Said there's a sandstorm approaching. I don't see it anywhere. Unless it's like way to the north or something. Oh, is this like one of those continuously sandstorm things? Okay, so you're asking me what it looks like. So let's go to the top real quick. I'll jump in our airship and we'll just kind of show you where everything's at. I'll keep calling it the airship. That tells you the games I play. There you go. So we already have the top made. And this is where we're at right here. So we've blown out the bottom of the base by a lot, as you can see. So we've doubled the size of the ground. I have to add a ramp to that side. We got our ramp on this side to come in. I don't know why I can't put anything right there. Like, I can't close that gap. But yeah, so far this is what it all looks like, and we've done a lot of micromanaging with down with getting the walling over here set up, and we're just moving onward to our technical second floor. Yeah, I don't know why. There's some weird geometry stuff going on over here. I don't 100% understand it. Probably gonna have to go kill some people to recharge my blood. I'm also just realizing that in order to use the big Atreides door, this thing, it's a 3x3. And all of my stuff is essentially like a 2x2. So in order to change it, I would have to... Actually, what is the end of my land? Yeah, I don't think I could. Not without just uprooting and moving the entire base. Because I can't go any further into this direction. Because that's all enemy territory. There's a camp right there. There's a camp up there. What time is it? It is 10 o'clock. I think I might call it here in just a little bit. So yeah, we got to move all of our crafting stuff up here to get rid of that. To get rid of that floor. I'm not getting rid of the blood area because I'm very okay with having all of my water just stored, you know, closely in the back like this. I just got to figure out how I want to put them on the second floor here. Generators, I guess I could stack over here off to this side. I could put all the crafting stuff right here. Oh, none of this stuff is water sealed. This is all just sheltered. What's the difference between water sealed and sheltered? Damn, what is the difference between water sealed and sheltered? I mean, this stuff doesn't degrade, though. There's no, I have to look that up. Water sealed. No, sorry. Oh, sheltered will protect from a storm. Water sealed allows you to spend time in your base without your internal water level dropping. Well, that's fine. So I guess that's more of a me thing than a machine thing. All right. I think I'm digging it. That's got to be a half support. Nope, there it is. Yep, okay, so that'll switch from water sealed to sheltered. As much as I'd like that, like, I like that that stairway is close to the other two stairways. All of this flooring has to be changed, except for this. All of these tiles need to be redone. We can do later. Yeah, all these need to have the other tile on them. Are there really no support beams for that? For structural? And that is probably clipping through what? Yep. Well, I mean, this would give a cool pedestal for a light. If I can build on top of it anyways. I mean, it could kind of get pulled off like that. I guess I could do that across the floor. Because I ended it, that's why. Because that doesn't continue down to the second floor. That's why that works. I don't think that'll work right there, though. Yeah, that one pops through. This side's fine because it's actually anchored to the wall post. I don't really need a support pillar here. Ooh, you know what? That might not work right there. Because I need something else. Find a locking spot. Alright, now I just gotta replace the rest of the stairs here. I have no idea how that light is even still functioning right there. Actually, how the heck is that light still there? There's no ground beneath it. God, I think these are the last set of chome I need to remove. Oh my god, I'm out of basalt. Are you serious right now? There it is. Entire base rebuilt. Fraction specific. Do we get enough blood? Are we good on blood? Oh yeah, everything's pretty full right now. But just in case we forgot how to use our blood banks. Yeah, so we're going to replace all of this with the standard tile floor. I just don't feel like realigning and removing everything, so I'm just going to ignore that. We're going to go get some blood from our neighbors right here. I don't think I have a blood bag on me. Oh, I got two. Okay. I didn't really know what this machine was until I got one, and it is super barbaric. Oh, I could have ran down the stairs here. Duh. Yeah, that wall blocks it, unfortunately. Yeah, there's still nothing I can do right there. That's fine. Oh, I literally just clicked deposit. Yeah, I didn't click all. Duh. Let's see here. So we'll get rid of this, this, and this. Now we just got to figure out what to do with this big middle space here. That will be the last thing we need to do on this base, is figure out what the heck am I doing with that. All of this has been replaced. Oh, I still gotta put a ramp there. But I think that's where I'm gonna call it. Yeah, because I can't keep that. I feel like it's worth mentioning that you can create half floors, but you don't have supports for it. I don't know what you would even need to do something like that either. God, it's creep listening to those things work. All right, I'm going to call it there. I'm tired. My hands are super sweaty. And we got through the first chapter of the week, so that's perfect. I will catch everybody later. I might stream tomorrow. If I do, it's clearly going to be more of this. I've got 2 more chapters to go through. We covered a lot of Lost stuff in the first 2 hours of stream tonight, so feeling really productive, feeling really good about that. Yeah, I'll catch everybody later. Hope you all had a good Memorial Day. Hope you all have a good week. We'll see ya.